Friends, if you are watching this video first time, then please subscribe to this YouTube channel, press the bell icon notification button and like this video so that we can update you from time to time. Friends, there is another judgment passed by the Honorable High Court of the Madras, which was delivered on 14th of August 2023, in which there is a writ petition number 23983 of 2022 and WMP number 22964 of 2022. And this, there are the three respondents made by the petitioner. And number one is the Government of Tamilnadu, number two is the District Education Officer, number three is the Headmaster of Erode District and the Headmaster of some high school, Municipal high school located at the Erode District. So the petitioner has, this is a writ petition, and the judgment is based on made on the writ petition filed by the petitioner, and in which the petitioner has challenged the respondent number 2 order, which has upheld the respondent number 3 order. So in which the petitioner was denied maternity leaves for her third child, and whether she is entitled for the maternity leave for third child, whether the High Court has granted the third child. So let's go through the contents of the judgment and how the court has analyzed. So let's please stay tuned to this video. Let's see what kind of analysis the court has made. So this is a writ petition challenged under Article 226 of the Constitution to issue a writ of certiorari Madras calling upon the records and impinged order owed at MU dot number so and so, dated 10th of August 2022. And second respondent orders was made on dated 29th 7th 2022, passed by the third respondent. So the main contentions, the order was made that the writ petition was filed to quash the impinged order, respondent number 3, which rejecting the maternity benefit leaves applied to by the petitioner, an order passed by the second respondent confirming the order of respondent number 3 and rejected the plea of the petitioner. So both two respondents has upheld that she has made a prayer for grant of the maternity leave for her third child, but it was rejected by the respondent number 3, and same when she has made an appeal, second respondent 2 has upheld the order of the respondent number 3. And here are the facts of this case: that the petitioner, she joined her government service. When before joining the government service, she has married to one name, it's mentioned there, on 6th of 1998, and she in the said wedlock she has given 2 daughters which were born on May 2000 and April 2022. Thereafter her husband died on 2004 due to ill health. So the petitioner got an appointment for lab assistant on 2017, and then she remarried with another man on 25th of January 2021, and in the wedlock she became pregnant, and she gave twin female children on 1st of March 2022. And when she became pregnant, and she applied for the maternity leave on 21st of January 2022 for the period between 1st February 2022 and 31st of December 2022. So as per her contention, she was eligible for 1 year maternity leave, which towards pre and post natal care, and her application was pending there without any consideration. And as per her contentions, that the respondent has misconstrued the fundamental rule 101A, which is applicable to state government servants, to deny her request for the maternity leave, stating that the woman employees are eligible to avail maternity leave only for 2 surviving children. There is no provision for the grant of maternity leave for the third child. So according to her versions, there is one rule that is 101A, which on the basis of which the respondents has denied the maternity leave on the grounds that this is only applicable for 2 surviving children, and she has already have 2 children from her first wedlock, and after when she married, so another twin children were born. She applied there for the maternity leave, which was not granted to her. So as per her contentions, the government has misconstrued, means misinterpreted the 101A of the fundamental rules. And another ground she has raised, that the provisions of Maternity Benefit Act 1961 was enacted in pursuance of the constitutional guarantee enshrined under Article 42 of the Constitution of India. So it's a social welfare legislations, and which is aims for providing social and economic justice to the citizens. So restrictions on the grounds of maternity leaves are not correct until the Maternity Benefit Act 1961 is suitably amended. So subjects relating to the population control, family planning, and maternity benefits all fall within the concurrent list, and therefore in the absence of any restrictions in the Maternity Benefit Act 1961, which is a central act, it's not open for the respondents and even the state government to apply two-child norm on the woman fall. She had made a version that since the Maternity Benefit Act falls under the family issues and family planning and the population control, all such related issues falls into the concurrent list, and there is no such kind of restrictions there in the Maternity Benefit Act. So as per her version, that the Maternity Benefit Act is a social and economic is a social legislation which provides social and the economic justice to the citizens. So it should not have to be misconstrued and it should be always to be interpreted in the favor of the citizens. So Section 5th of 1961 does not impose any such two-child norm. So the impeached order out have to be quashed. These are the grounds which she has made in the writ petition. The court has duly considered, and the Government Council has opposed, and the respondent number 3 also filed a counter affidavit which and has opposed. Now the main contention arises whether two children born to the petitioner prior to the joining services. The main contention is that the petitioner has 2 children born to the petitioner prior to joining the government service. After government services, twins were born from the second marriage. So it is her contention that she has not the maternity leave previously, and the rejection of representation cannot be sustained in the eyes of law. So as she has raised this ground because she joined the government services only in year 2017. Prior to that, 2 children was born. When that time she was not there in the government services, and as per her version, that she has not even availed the maternity benefit even for the ones. And during her these twin children were born from her second marriage. So her prayer, which was rejected by the authorities, is not sustainable. So it's a social welfare legislation and is applicable there. And the fundamental rules which the respondent has quoted is totally contrary to the Maternity Benefit Act. So and cannot be pressed into the service. And she has also relied upon 2 judgments: K.M. Devi versus the Government of Tamilnadu and others, and Deepika Singh versus Central Administrative Tribunal and others. And the Council of the Advocate General submitted that the GUN number and details about the GUN number, on the basis of which the prayer was denied. So now the court has made an analysis. Court says that fact is not disputed that the petitioner has 2 children from her first husband. After the death of the first husband, she married second time. and she delivered twin children after joining the services. And now the court has interpreted the section 101 of the fundamental rules, and which clearly says that provided, kindly see the proviso 101, provided the Maternity Benefit Act refer number 1 and 2 shall be given to a married man government servants with less than 2 surviving children. It's clearly mentioned is that maternity leaves which is applicable is granted to the married man government servant with less than 2 surviving children, provided that in case government servants with 2 surviving then born as twins in the first delivery, maternity leaves shall be granted for more than foreign delivery. As per the FR rules, they say, suppose in case during from her first delivery, twin children are born, so it means she has availed only one delivery. She has availed the benefits for the one delivery, but twin children are born. So, as per the rules, she can't be denied a second benefit, a second maternity leave. So, this is there is a proviso there as from the 101 rules. And how the court has interpreted it. Let's see. The rules makes it very clear that such leaves can be granted to a married woman with less than 2 surviving children, not exceeding 65 days, which may express from pre-confinement rest to post-confinement recuperation in the opinion of the government servant. The fundamental rules make it clear that benefit is available to married women only with 2 surviving children, and non 2 surviving children made as a mandatory to avail such benefit under such rule. And now they have considered the section 2 of the Maternity Benefit Act. What does the section 2 says? This is called the application of act. And 2(1)(a) subpart says to every establishment, being a factory, mine or plantations, including any establishment belonging to government and to very establishments wherein the persons are employed. So main focus is the establishment. Now section 3(e) says of Maternity Benefit Act says establishment means a factory, mine, plantations or establishment where persons are employed for exhibition of equestrian, acrobatic and performances. And when the section read with in conjunction with the establishment, this makes clear that establishment defined under the Maternity Benefit Act will fall within the ambient of the Maternity Benefit Act. Now, the court says that petitioner, being a government servant who is not employed in any establishment as defined in the Maternity Benefit Act, she can't claim the benefit as per the Maternity Benefit Act. The court says she is not even employed in an establishment. The definition of establishment is very much clear in the section 3(e). And if she wants to claim under the Maternity Benefit Act, she must have to work under the establishment. And so she is not working in any establishment, so the provisions of the Maternity Benefit Act is not applicable. Is not applicable to the government service. Now, other judgments are also to be relied. Finally, the court has held, when the state has the policy decision, the fundamental rules is applicable to government servants, the petitioner can't claim any benefit under the Benefit Act, which is not applicable to the government servants except in the employees employed in the establishment as defined in the Maternity Benefit Act 1961. The court has made it clear that it's a policy decision. And when any state made any policy, then the provisions of the act is not applicable here. So the provisions of the Maternity Benefit Act is extended to the employees who are employed in an establishment, which has already been discussed above. So this act is not applicable to government servants. The same is binding in the case on the hand. Other judgments are also relied, the chairman, managing director. So Sanchar Nigam Limited and versus C.R. Vilas Kumari and others, which held that as per section 43 of CCS rules, when maternity benefit facility has not been availed in respect of first two children, in respect of the third children, grant such leave facility. So court has held that whether the benefits of the maternity benefit is applicable or not is the issue before the divisional bench. And then another judgment was relied, Deepika Singh versus Central Administrative Tribunal. So in above the case, the applicant has availed the child care leave for two children born to a spouse from the first marriage. The para number 17 of the above judgment has held. So the Honorable High Court has held, since in the Deepika Kumari case, the court has granted the relief to this such extent, since two children were born from her the first marriage, who are the biological children, which are not born from her but from her spouse. And after being married, she is entitled for the benefits even for the third child, because she is the sole biological mother. She is the sole biological child for her sole biological child. She is the mother for her sole biological child. Now, Apex Court has extended the benefit merely on this count. The appellant spouse has two biological children in the first marriage. It will not infringe upon the entitlement of the appellant to avail the maternity benefit for her sole biological child. It means the first two children were born from her first from her spouse. So, and it will not. Court has held that it will not be denied. It will not infringe the benefit if she wants to have her own child, sole biological child. So, the court has granted and extended the benefits to the petitioner. So, since she is the only sole biological child, which she has, being as a third child, she is only the sole biological child. So the court has held it will, if we deny, it will cause infringement of her rights. So this judgment is also not applicable here in this case. The facts of the present case is that the petitioner has four biological child. Now court has interpreted it in this way: since she is the mother and she has four biological children, and when the state policy and fundamental rules restricts benefit for the third leave, the court is of the view that petitioner, as a matter of right, can seek the maternity benefit on the basis of the Maternity Benefit Act. So court has held in this case, since she is the biological mother for four children, and the court has held, since the state has made the policy to restrict their employees to avail the maternity leave for the third children, and this policy decision shall not be infringed, shall not be interfered, because the court is of view that the matter of the right, the petitioner can't seek the maternity leave on the basis of the Maternity Benefit Act. It means the provisions of the Maternity Benefit Act is not applicable, and since state has already framed their policies under the fundamental rules, so she is not entitled for this. So court held that no interference is required. So accordingly, the writ petition is dismissed. So this was a judgment passed on 14th of August 2023. Hope you have liked this video. If you have liked this video, please subscribe to this YouTube channel, press the bell icon notification button, and like this video so that we can update you from time to time. Thank you.